it is you have to. Oh, here we go. Now we're recording. The duty of care element is you have to engage in reasonable due diligence. You need to look into stuff. You need to ask questions. It's a lot more involved than that, but like super distilled, concentrated duty of care, that's what it is. Duty of loyalty is the harder one in practice sometimes. It's putting the corporation's needs ahead of your own. It's basically subordinating your personal interest for the best interest of the corporation. So with that backdrop, Paul, why is the Delta Dental case, like what is the case and why was it important to you?
Okay, so Delta Dental, it's a case called California Dental Association versus Delta Dental of California. And you're asking, how does this in the world apply to a homeowners association?
We'll get there.
The reason it applies to a homeowners association is because the defendant in that case, Delta Dental of California, was a nonprofit mutual benefit corporation, which is the same kind of corporation that
all of our HOAs are.
They're all the same kind of corporation. In that case, there was the California Dental Association was suing a nonprofit mutual benefit corporation, Delta Dental of California, because they thought they were being treated unfairly under a contract. In the opinion, the court goes to a great extent to distinguish the difference between general corporate law and nonprofit mutual benefit law, because it was important both for that case and for the cases that Jasmine and I are always handling. And in the opinion, the court cites extensively to all cases that we've talked about many, many years and for years.
Francis
T.
Ravenscoe.
They rely on, Cohen. They rely on all HOA cases in basically holding the following: that the directors of the association, Delta Dental of California, owed a fiduciary duty not to the members of the plaintiff party. They owed a duty to the corporation of which they were the board of directors of. So basically what that means, and we see this all the time, Jill mentioned I do enforcement work, but I also defend homeowners associations against claims just like that. Some owner will say, you denied my architectural application. You're in breach of the fiduciary duty you owe to me. That's false. Under this opinion, which is only like 3 or 4 months old, the duty by a director is owed to the corporation, not to the individual members of the association. If an owner says, you muted me on the Zoom meeting, you breached your fiduciary duty to me, the answer is no. I don't owe you a fiduciary duty. I owe the corporation a fiduciary duty. And that fiduciary duty, as Jasmine mentioned, is also captured in the law. It's Corporations Code 7231. And what it says is that the directors of a nonprofit mutual benefit corporation owe a fiduciary benefit to discharge their duties in a manner such director believes to be in the best interest of the corporation. So if it was correct to deny an architectural application because it didn't meet the architectural standards, that decision was made in the best interest of the corporation and the fiduciary duty has been met. It's really important because time and time again, we're being faced with these claims that the board has breached the fiduciary duty to me. And in the opinion, the court says what I've been saying for years, which is directors can't owe a fiduciary duty to the corporation and owe a fiduciary duty to 100 condominium owners. That's impossible. And what the court actually says, quote, it would be impossible for directors guiding the corporation's conduct under contracts to simultaneously fulfill fiduciary duties to the nonprofit corporation and to the contracting members. Your contracting members are the members of your association. The contract is the CC&Rs. The fiduciary duty you owe is to the corporation to adhere your conduct and operational decisions and enforcement decisions according to that document. And I don't know if we don't, I don't know if we're going to get to this later. Maybe we'll get it to there, but that fiduciary duty doesn't necessarily mean you have to be right all the time, but we'll get to that in a minute.
And let me just say, I'm seeing that people are trying to raise their hand on here. We're not going to answer the raised hands, but type your questions in the Q&A and we'll try to get through those as we go.
So, one of the things that I think was super interesting in this case, as I was reading it through the lens of homeowners associations and the types of things that homeowners, consistently raise, was the fact that it went to great lengths in this case to explain why the association directors, these nonprofit mutual benefit directors, couldn't owe the duty to the individual members and the corporation, because under general corporate law, so for like public, for-profit corporations, their boards of directors do owe a duty to both the corporation and to the shareholders. And the reason why that can be the case is because the shareholders have like an economic vested interest. And you sit there and say, all right, well, if the board's responsibility is to carry out the CC&Rs, and in a parallel, application in this Delta Dental case, the contract that the dental association, Delta Dental, was basically adhering to when they changed certain rates and they gave certain amount of notice to the dentists, and the dentists under the terms of their, contract could basically take it or leave it. And it's like, you got 120 days to take it or leave it. And that's, and the dentists were saying it's unfair that you exercised this discretion in changing rates unilaterally. And how often, Paul, do we hear that type of claim from homeowners?
All the time.
All the time. You didn't maintain or repair X, the roof, the pipes, the walls, my house, in a standard that I think is fair. And so you've breached your duty to me. And I think that's like a really helpful case, even though, like, what does dentists have to do with HOAs? Trust us, it's there. But it was when I was reading this, it was like, this is such an excellent case for us, because it addresses the things that homeowners are often complaining about with respect to a board's exercise of its discretion. In this case is like, hey, as long as it's allowed to exercise discretion, the board gets to do that.
Mm-hmm.
And if it was not in, direct violation of the contract, then it's okay. And I mean, I think that's just an important reminder for board members and managers to take away from this discussion.
Right. And it's also important for board members to understand this, because board members are always, getting people to serve on a board is really, really hard to do, because they think, well, if I'm on the board, then everyone in my community has a right to sue me.
Yeah.
It was not hard to get Jill on the board. Our wonderful Jill is a volunteer,
Right.
voluntold board member of her own HOA.
I'm as crazy as many of you out there.
But I mean, the point of this case is that they don't have a direct claim on a board member for a fiduciary duty owed to them, because this case says that the duty is owed to the corporation. The corporation could sue a director for breach of fiduciary duty, but not a member of the association. The other important thing to remember about this is you're allowed to be wrong. Okay, when Jasmine talks about exercising your discretion, as long as your conduct is falling within what the corporation's code, that you're making a decision in your judgment by talking to
Reasonable investigation.
You talk to consultants, lawyers, tax people, plumbers, property managers, contractors. All of these folks that you interact with all the time are ways that you satisfy your obligation as a director under the corporation's code and exercising your fiduciary duty. So if a contractor says, you don't need to replace the roof, we can just do spot repairs, it's going to be 20% less expensive than a full roof repair, and it'll last for another 10 years. And the board says, well, that's what we're going to do. then Joe Blow member says, I deserve a new roof. I want a new roof. And you're breaching your fiduciary duty to me and everyone around here by not putting on a new roof. False. You are making a decision for the corporation, not for Joe Blow homeowner.
Paul, how is it that members of an HOA are not considered shareholders of the association?
They are not considered shareholders because it's a nonprofit corporation. They didn't buy their home to make profit from the operations of the HOA. They bought their home so they could live in it or rent it out or do whatever. The way the corporation is set up is they've elect a board of governors or a board of directors to make decisions in the best interest of the association, which is the managing entity of the common areas. And you'll make money by managing common areas, you know?
I promise you. We get those complaints every once in a while. Boards are getting kickbacks, and that's a different discussion for a different webinar. So, I mean, it's just helpful for board members and managers to hear over and over that what fiduciary duty really is. And it's that duty of care, and it's that duty of loyalty. And Paul is 100% right. The courts don't care that you got the answer right. They care that you followed the right process in making the decision. And it's that lack of following the process where HOAs get bit in the butt. And I mean, like, that goes back to the Affin versus Portofino case, now it's about 20 years old. But, the HOA in that case did something every single time the plumbing issue was reported by the homeowner. So, and, people can be like, how did they lose that case then if they always sent out the plumber when the, plumbing block was reported? And the court took them to task in that case because he said, board, you never asked questions. Why are we still fixing these pipes? And so, really engaging in that good faith investigation, and this will dovetail into reasonable accommodations next, but, really engaging in that due diligence. And I mean, for everything. When crazy homeowner, that's like, oh, they're constantly kvetching and, complaining about something, you got to investigate it first. Yeah. You don't have to keep re-investigating stuff, but like, you do that investigation, it actually protects associations to ask questions of subject matter experts. I know that a lot of times managers, feel constrained because like, well, the board doesn't want to pay money. Mm-hmm. And you're like, but sometimes that, $300 can save you monumental fees in terms of liability exposure on down the line. And so it's not always the best case to be penny wise and pound foolish. And, I really do encourage board members to, listen to the guidance that their property managers and their management companies are providing, because it's often for your best interest. They're saying, hey, we need you to contact legal counsel. We need you to contact the CPA or, this construction expert. It's not because they're trying not to do their job. What they're trying to do is connect you with the, external sources so that you can satisfy, we did this reasonable investigation. You don't call Paul and I and say, can you look at the roof?
Right.
Hey, I'm afraid of heights and I'm not going on your roof, so it's like, but it would be appropriate if there's, roof leaks, like call the roofing contractor and let's look into that. So anything else that we should know or, talk to board members about on fiduciary duty?
Well, the way that a board member should think about fiduciary duty is, I'm not making this decision on behalf of my own personal life experience. I'm making this decision on the best interest of the corporation. Is this the right move for the corporation? If a contractor is telling me that we can spot repair the roof rather than specially assess everyone for a new roof, and that these spot repairs will last another 10 years, maybe that's the best decision for the association now, is to do the, spot treatment and avoid a special assessment. Or it could be the opposite, where the contractor says, well, yeah, we could do a roof repair, but it probably is only going to last maybe 1 or 2 years. If you want to repair your roof now, it's going to be X dollars. It's going to be much more in year 5. And then the decision matrix says, yeah, we need to do a roof repair now. and it's going to require a special assessment. It's going to be painful, but we're saving the corporation pain down the road. Okay, so that's what your decision matrix is about. So that's the kind of like, you're making the decision as if your client is the association. And that's basically the approach that, I try and tell board members to take. It doesn't necessarily stop people from, suing the board or the association for breach of fiduciary duty. But this case helps us get rid of those cases very early by saying, you don't have the ability to do that. This case says you don't. And, you're out of court.
Okay, let me, someone typed in this question. Can those costs, like if someone were to do, the board were to do some testing, could those costs be passed back onto the homeowner if the investigation concludes that the issue is not the HOA responsibility according to the CC&Rs?
Well, that's a tougher question to answer, because HOAs do have costs of doing business, and we'll often get these questions. Hey, we don't want to, have to pay to look into this. Can we bill the homeowner back?
Mhm.
And a part of the answer is going to be, it depends on what your CC&Rs say. They're all over the map on that specific issue. Sometimes they'll allow for imposition of reimbursement assessment or special individual assessment. They'll typically be called something around that. If it's to gain the owner's compliance, right? Like, all right, well, if this is a homeowner that was saying, I think there's a roof leak because there's, soggy drywall in my ceiling, I think that would be difficult for the board to say, well, you made us investigate this, right? That's your cost of doing business.
Right.
Like, my job was to report it to you, and then the board's responsibility is to investigate it. But alternatively, let's say that it's, some sort of an internal unit issue, and the association gets called in and, hires a contractor, and they incur costs, and ultimately they discover, oh, that was a homeowner maintenance responsibility issue. It wasn't a common area responsibility issue. If the CC&Rs allowed for the imposition of that reimbursement assessment in carrying out a homeowner's duties, then that would be a circumstance where, yes, you could seek recovery.
Yeah, I echo what Jasmine says. The document is your guide. And, sometimes you read this document and you can't make heads or tails of it. That's why Jasmine and I have jobs. Because we can, guide you in a certain way. I've seen plenty of CC&Rs that say just what Jasmine says. You can reimburse assess when you have to enforce the rules against someone. On the example that's been presented by Jill, that's a tougher one because, the guy said, I have a roof leak, and that's not really enforcement against this guy because he's not like playing music at, 2:00 in the morning and keeping everyone awake. For that, under the CC&Rs that say we can reimburse assess you for costs to enforce, you can totally get a reimbursement assessment for that one. It really depends on what the documents say.
How often should people get rewriting their CC&Rs?
That's a tough one. I will typically say, every like 20 years. Some communities do it more frequently than that. Some communities still have CC&Rs from the 1920s, so we're 100 years in and still kicking.
Mm-hmm.
A lot of times it comes down to when you have enough pain points from your CC&Rs, whether they are vague and, difficult to discern. Certainly that's a good time to consider amending CC&Rs. When they are, simply inconsistent with the law, a lot of times, associations will want to get rid of all the declarant related, provisions from when the community was originally constructed. And so there's different reasons why communities want to get their documents amended. And it's generally like, well, it's not an inexpensive or it's not a time efficient process. I mean, they'll typically take, on the low end, 6 months, and that would be like everything is gelling and everything's like moving right along. But normally they're, a year or more of investment in time and, certainly monetarily as well. So it's something that communities should really, if they see, pain points in their documents, they should plan ahead for it, but build that into their budget for a future fiscal year. And then, have the board sit down and consider, how do we get this thing passed. You know, I live in an HOA myself, and there's around 1,700 homeowners in it. And this is before I lived in the HOA, so there was no conflicts of interest, but I'm the person who drafted the CCNRs for my own HOA. I know, that's kind of crazy.
It's written conveniently, Jasmine's the only one who doesn't have to bring in her garbage cans.
Totally kidding. And, you know, when we went through the CCNR vote, I was special counsel just for that project. We had 92% of our homeowners vote. And, you know, people are like, how the hell did that happen? And I said, it's because the board was really, really conscientious about how do we get this across the finish line? And they took it like it was a, you know, NASA level project of like, we got a moonshot, guys. And so it is possible for documents to get across the finish line, but it will typically take a kind of village approach by boards of directors.
And what if they can't get, what if like 51% of their community is not active and they can't get the vote?
You can go hector them with billy clubs at their front doors. I'm totally kidding. There is a court petition under the Davis-Sterling Act that does allow an association to petition the court to have the court lower the approval threshold. There's certain, you know, like statutory prerequisites that have to be in place, but there is a mechanism for a judicial approval.
Are raffles still allowed?
Raffles?
Yeah, so have you ever heard of that?
Oh, like if you vote, you can participate in a raffle?
Correct.
Oh, who would fund the prize?
The HOA.
The association?
Yeah. And it might be like, I don't know, $100 gift card to like Target or something.
Yeah.
But in order to enter, you got to submit a ballot and it's got to be valid.
Well, I think there are requirements regarding like raffle reporting. So the HOA, if you were going to have a raffle to encourage and like juice the vote to get people to turn in, you'd want to definitely evaluate the reporting requirements, because I know there are reporting requirements regarding raffles and those types of things. I mean, sometimes I'll have HOAs bring in like a In-N-Out burger truck. Hey, everyone wants a burger. So there's definite ways to try and like, you know, increase the probability that you can successfully pass amendments to your CCNRs. But good question. So moving on to reasonable accommodations. And this is a, you know, issue that has, you know, increasingly become a bigger part of our practice over the last number of years. And, you know, reasonable accommodations for, you know, the untrained, you know, like uninitiated, where you're like, okay, I've heard about that, but, you know, HOAs are subject to federal and state fair housing laws. And under those fair housing laws, much like an employer has the same responsibility, HOAs have to provide disabled residents with reasonable accommodations. It doesn't mean it has to be a homeowner. It could be a tenant. So it's a resident. Heck, it could even be a non-resident, but someone who comes and visits for like, you know, if my mom's coming and staying with me for 3 months and she, you know, uses a wheelchair and I need a ramp to, you know, the front door, even in that circumstance, a reasonable accommodation or modification could be necessary. So accommodations are simply exceptions to stated practices, rules, policies, and modifications are changes to the physical, you know, the physical infrastructure of either the common area or the person's separate interest that are necessary to allow the disabled person to have full and equal access to use and enjoy the community. So that's what a reasonable accommodation is. It's an exception to a policy or practice. And, you know, some reasonable accommodations are easy. You know, if you've got the you know, person and they have PTSD and they need a, you know, special service pet. I've had a director who had vertigo and she had a dog who would alert her before vertigo spells would come. And so it's like, oh, okay, there are somewhere we're going to grant that. And it's not a difficult decision for a board, but more and more I've been seeing really complicated questions on reasonable accommodations. And you sit there and you're like, you know, a recent request was from an association that has an elevator. They got one elevator and they've got disabled resident who lives on the 5th floor and they're going to have to take the elevator offline for 6 months while it gets retrofitted and whatever you have to do to like redo elevators because they're not forever. And, you know, one of the people said, well, I want the association to install a like alternate elevator. And you're like, how do we even like evaluate that?
Right.
And that goes to the reason, like that goes to fiduciary duty. Like now you're into the looking into this and evaluating like what's possible here. And, you know, every once in a while I'll get pushback because the board will say, we're going to have to go and like hire a contractor to come out here and tell us if we can do this. And I'm like, yes, that might be a cost that you have to incur. And, you know, it's typically pushed back on, but this is a reasonable accommodation or reasonable modification. You told us that the homeowner pays. And I say, well, it's a little bit more nuanced than that. Yeah, the homeowner would pay for the actual modification, but the board's due diligence in researching the issue, that's the HOA's cost of doing business.
Mhm.
And that's part where sometimes boards struggle because, you know, they'll say, but it's the homeowner's responsibility or the requesting party's responsibility. And you're like, yes, to pay for the elevator, this extra elevator that's, you know, was recently requested by a client. And it took some doing to explain to the board like that. If you've got a contractor who's like, yeah, there's this way that we could do a, you know, like a temporary elevator lift. You know, let's just say it was going to cost $50,000, like that part would be the homeowner's cost to bear.
Mm-hmm.
But the investigation of like hiring that contractor to come out and look at the issue and give them the analysis and bill, that was a HOA responsibility and cost.
Mhm. Yeah. The question is that, you know, I recall, and this also relates to fiduciary duty, is the threshold for a reasonable accommodation is a disability. And the legal definition of disability is vast. It's like a lot of things, and it seems to be getting bigger. And sometimes boards struggle with, well, do we even have to, you know, take this up as a reasonable accommodation? Is what this person telling us really a disability? That's where also fiduciary duty comes in, because then you're making a decision not based on how you view this person. Some directors might say, I saw this lady cut in front of the line at Safeway, so I know she's not trustworthy, so I don't believe that she really has a disability. That's not fiduciary duty, because you're basically using your own personal assumptions about this person in deciding what is an issue before the association on whether to grant a reasonable accommodation and whether this person has an actionable disability under the law. If you're not sure, reach out to legal counsel, reach out to other consultants about disability, whether this qualifies as a disability. Like I said, the definition is huge. We're not going to go into it now because it's literally like this long. But that's the kind of decision-making you need to engage. You have to put your personal view of the requester aside and make the decision in your view as an advocate for the association, a protector of the association. And a protector doesn't necessarily mean no one has a disability, I'm protecting the association. Because that might not protect the association from a fair housing claim. Okay. On your issue, what about like switching? What about if one owner on the first floor would switch units with the person on the fifth floor? Is that a reasonable accommodation?
It is a possibility in the interactive process. So, you know, the way a reasonable accommodation processes occur, the requesting party says, I want X. They don't have to use the magic words like I'm requesting reasonable accommodation. Sometimes it comes across much less you know, obvious. And that can be tough for boards and managers to, you know, to discern because they don't use magic words and they don't have to. And there is a greater burden on the housing provider to like sort of understand like, oh, this had a whiff of maybe reasonable accommodation territory. So we're going to treat it like that. And, you know, when in doubt, like it's okay to say, hey, we've received request X. We are like interpreting this to be a request for a reasonable accommodation. Like, please confirm this. If that is confirmed, yes, then we are responding on the substantive basis of do you have a disability? I was literally writing an opinion letter right before I walked in here. An individual had requested the ability to get to drive his electric motorcycle through a part of the a part of the community that is not permitted. And, so the first question is, all right, well, the person's request provides I have a disability, but it wasn't a third party who, it was just him self-attesting. And in very few circumstances, self-attesting is okay to do. But in most circumstances, the requesting party needs to provide a documentation from a qualified third party. A lot of times, people may make the mistake that it's a doctor. That's a person who could, but it is not restricted to just doctors who can provide, the confirmation of, a person having a qualifying disability, because not every disability is subject to the fair housing rights. And so, a lot of them are for sure. And as Paul explained, that definition's getting, more and more expansive. But, it's just part of that due diligence to the corporation. And I tell, boards this, and I, relay this to owners in communications that I draft, say, the board will be granting, if this accommodation is granted, that means we're giving you an exception to a policy we otherwise have a legal duty to uphold and enforce against you. And so we need to have our documentation ducks in a row for the corporation's benefit to help us, basically defend if someone wants to come at us and say, you're not enforcing the documents or you're enforcing them unfairly because person X gets this, but I don't. And so
that's a very good point, because that documentation is crucial. If that, disgruntled owner says, you're allowing this person to have 2 dogs and there's a 1-dog policy here. Everyone's gonna want to have 2 dogs, and say, no, just hold on. There's a documented disability. We engaged in the interactive process. The person provided us with evidence from a third party that their person has a, severe depression or anxiety or something. And it's debilitating and it affects their work life and home life, which are like the elements of the definition. And we have a legal opinion that says, yes, this meets the definition of disability. You've engaged in the interactive process. So then now you're like rock solid if in case anyone, says, oh, I'm going to sue the board for,
discrimination.
Right.
We're not all getting the same thing.
Exactly.
And so the directors are allowed to share that much detail about someone's disability?
No.
I didn't what? Well, he has
I'm sharing with them.
Right. But if you're going to tell the disgruntled homeowner, they provided documentation.
No.
You don't even get to tell.
Jasmine's depressed, got anxiety. She's a mess. We have to give her the extra dog. And then all of a sudden, the whole community's like, did you know Jasmine's a wackadoo?
So met her dog.
This is true. But that's a very good point, Jill. And it's important for board members and managers and homeowners to understand that under the California Constitution, people have a right to medical privacy in our state. So the board cannot provide any information about a person's approved accommodation or modification. And that can really come at, that can create a lot of conflict and tension where you're like, so Paul got hardwood floors and he lives in the 2nd floor and he's not allowed to have hardwood floors. None of us are. Why does Paul get the floors? I wanted to and they denied my application. And it's tough because boards are put in a bind where they can't say why. Mm-hmm. And even in the reviewing of the request for accommodation, it's not in the Davis-Sterling Act. So for everybody's like, she doesn't know what's in the Davis-Sterling Act. But you're 100% going to put it on executive session and you're just going to put legal issue. Because you can't put grant Paul's reasonable accommodation because that would be, disclosing that he, something that he has a right to privacy about. And so, these things need to be handled sensitively and, really delicately because you need to make sure your documentation's there, but you need to make sure the meeting that was properly agendized first and, in a way that doesn't disclose the requesting party's identity and all of that. And when, I get this question from boards and like, well, what are we supposed to say? Because everybody knows that she's got the 3 dogs.
Yeah.
And you simply say, we understand, and please rest assured, like the association has, consulted with legal counsel on this. And, that's as much as we can, say about the matter.
Yeah.
And, sometimes homeowners really like grind their managers or grind their, boards of directors. And the best thing that you can do, it's kind of like when Paul's in, enforcement litigation and homeowners are always, barking up the manager's tree, like, tell us what's going on. Is to say, our counsel has instructed us not to, provide, information about the case, and just to sort of like have to be okay with putting that out there and then just moving past.
Right. And you can always refer to like, what California law doesn't allow us to do, to give you the information you're requesting. I mean.
And that happens frequently when homeowners do like, requests for association records under Civil Code 5200. They may say, I want all of the letters that have been sent to anyone in the HOA about denials of architectural applications. And then, the HOA is like, uh-oh, what do we do? What do we do? And I'm like, well, that one just gets like, that's not on the list. You don't give it.
Yeah.
And it's tough because, homeowners, like boards and managers, often want to provide information like, hey, what's the big deal if I give them this information? You say, well, there's a lot of big deals. Once you like give this person this record that they didn't have a right to get in the first place. When I ask for the record and you say no, and I say, well, they said no because I'm a female, I'm, being discriminated against. So it's like really remaining, like your fidelity to the law. And like, we do that and nothing else. It really helps to lower liability so that you don't get like discrimination claims.
Right.
We're getting a lot of questions about pool areas.
Okay.
And what kind of accommodations need to be done for pools, ramps?
Well, so
stairs?
the answer to that is the requesting party is the one who will make the ask. Hey, I need a ramp so that I can access the pool. I need a swing, the disability swing where it's like mounted to the side and it helps drop you into the pool. So the requesting party is the person that has to come and say, I want X. And then the board has to go through the evaluation. Is it reasonable? And I know there was a question in there about, well what's reasonable? Funny thing, there's a statute about that. And, distilled down very, very quickly, reasonable is whatever the requesting party asks, unless it's unreasonable. And unreasonable is defined as either imposing a undue financial burden, which means there is some cost that a HOA may be expected to bear. If I have to swap people's parking spaces and it's going to cost me $1,000 to mount a sign and restripe some stuff, that may be the HOA's responsibility to bear that cost. So it's either an undue financial burden. Hey, it's going to be $50,000 to build that external elevator, and we're at 12% funding.
Yeah, not reasonable.
We don't got the cheddar.
Right.
Or it will require a fundamental alteration in the way the association does its business. And here's an example of a case that we handled in our office that had that issue. It was a, stacked condo project, and they had a, mail room that was accessed with keys. So, it wasn't just open to a random person who can walk in off the street. And they have, their little mail slots. And that's where Amazon and all those types of companies would come and drop off packages. A resident, she was a tenant, she had a disability, and one of the requested accommodations that she made to the HOA was, I want packages brought to me. And the HOA was like, we don't have any ability to like direct Amazon. If we had that ability, we would be retired. You know what I mean? But they're like, we don't have the ability to tell Amazon and, private package companies like where they'll deliver your packages. So that one's not on us. We can't do that for you. And if you're asking us to bring you your packages, that's a fundamental alteration in our business operations. Like, we are volunteer homeowner directors. We conveniently don't sit around and be like, Jasmine got another package from Amazon. The woman orders a lot. This is the third, delivery window today. And this person actually filed a fair housing claim against the association. And as to that part of the claim, even the, California Civil Rights Division, that's the entity in California that oversees fair housing claims, even that entity was like, hey, that would be a fundamental alteration of the business operations of the HOA. Like, they're not in the package delivery business. And so, the association's denial of that request was upheld as being an appropriate denial. The then question is, well, is there anything the association can offer? Because that's part of this interactive process that Paul and I have referred to is, was there anything that the association could have offered? Because basically, if you're saying, no, I'm not going to bring you your packages, and I'm also not going to direct Amazon to do the same, then is there something that we could offer? And, in that case, there candidly wasn't, because it's like, hey, you could get a offsite, post office box where, and that person was unwilling. So, but it does require the board to come back with something unless there's literally no alternative. And so, in my build an outside elevator case, it's like, hey, we've investigated this outside elevator thing and we couldn't do it because, structurally or whatever, there's no space, et cetera. It could be, hey, that was going to be an undue hardship and you're also not willing to pay for it. But it could be, maybe we'll see if we can find a person who will swap units with you.
Right.
I mean, that's an interesting and novel approach, but it could be that the association makes the ask. It could be that they say, hey,
on your package deal, there's another approach. I mean, every time Amazon delivers a package, the person gets an email, says your package has been delivered. So the person who wants the package brought to their door, I suppose, might want to put a flyer up or something on the agenda, like, I would like to hire someone to bring my packages to me. And I will email you when I get the email to bring my package to me, and I'll pay you, I don't know,
$2 a package.
$2 a pack, whatever you can negotiate.
Sure.
I'm sure there's some enterprising teenagers out there who might want to get an extra $2 to $5 just to walk a package up the stairs or something.
If it's Jasmine, they're getting more than $2. a lot of Amazon delivery.
Right.
So, that is the point is that reasonable accommodations are sometimes complicated and they do require investigation and due diligence. And, every once in a while we'll get a, board that's like, we're just not gonna. And, we need to bring those boards back to the side of, we understand that it might be like, it's the squeaky wheel who's making the request. And, they've wreaked havoc on us for issues 1 to 100 for a decade. And, there's a sense of exasperation. And it's like, even if the board has a sense that it may not be a bona fide disability, and it's tough. Like, Paul, how many times have you had to tell a client, hey, I recognize that there may be a, sentiment that this is not a bona fide disability, and that they went and got the, letter from Dr. Burke. There's literally a reasonable accommodation doctor in Los Angeles named Dr. Burke. He's an internet doctor, and he will give you the, service pet. Like, you email him $50, he'll send you your, certification. And, boards would be frustrated, like, this isn't legit, and we know it. And, it's unsatisfying for Paul and I to be like, we understand that this may not be legit, but if the association has the documentation, the risk is far greater in saying no than in approving the accommodation.
Right. And that goes to the fiduciary duty aspect of it. Well, squeaky wheel. This person is a squeaky wheel. I know her to be a squeaky wheel or him to be a squeaky wheel. That's your personal information clouding your decision for the association.
Yeah.
So that's, you're making decisions for the corporation based on information given to you by, lawyers or contractors or
managers.
And yes, she is this, or he is the squeaky wheel. He's always asking for some sort of like exception to the rule. But it's documented. We engage in the reasonable accommodation process. We've engaged in the interactive process. And in our judgment, it qualifies. And we're doing this even though we have a little heartburn about it, but we're making the decision for the corporation.
Yeah.
Not against someone who is against it, not for someone who's for it, just for the best interest of the corporation.
Was it always the case where you could ask for proof or third party, or is that new? Someone was asking.
No, that's been part of the reasonable accommodation process, but I did see a question that basically is saying, does the Americans with Disabilities Act in particular apply to residential homeowners associations? And
Construction.
generally speaking, the answer is no. However, the Americans with Disabilities Act will apply to parts of associations if those parts are open and available to the public. So I'll give an example. Let's say that you're a building in the city and you've got a Target on the bottom floor and it's a nice little high rise above. That part of the association, maybe part of the parking garage, maybe there's a bathroom in the parking garage and the Target area, like all of that part would be subject to Americans with Disabilities Act because it is open and accessible to the public. Conversely, if it's, Jill's building, she got a condominium and, it's next to a park. So maybe the park is ADA compliant, but it's not your park, but like her building, the condominium itself is not subject to ADA. And so, because it's not available for people in the public to just go in and enjoy their, your common room. It would be nice though.
So is it a good, like, think ADA equals public?
Yeah.
Reasonable accommodation equals someone who is in this building.
Correct. And so that's the thing that sometimes homeowners, people can get a little wrapped around the axle that ADA may not apply, and in most associations it won't. However, you still have the California Fair Employment and Housing Act and the Federal Fair Housing Act and the California UNRRA Act. So those are three different statutes, all of which apply to associations and all of which do require grants of reasonable accommodations and reasonable modifications. And so it's important to understand ADA may not apply. And why ADA matters, if it does or doesn't apply, is because the ADA imposes the payment obligation on the housing provider or on the public entity. Conversely, the California Fair Employment and Housing Act and the Federal Fair Housing Act, they impose the duty to pay for the thing, the reasonable modification, on the requesting party. So that's why it's so important. Does ADA apply or not apply?
What if we were going to upgrade our pool area? Should we preemptively go ahead and make it ADA compliant?
I will typically say this, we're not getting younger. I mean, being super candid, the more accessible your community can be, the more potential buyers you have to live and enjoy the community. And so as a voluntary, compliance, I will recommend it to the extent feasible and reasonably possible. There are some, communities where it's 100-year-old building and you're like, that elevator ain't ever changing its size. And, so sometimes it's not possible. Other times it might be cost prohibitive. And, if it's not a requirement, then you go back to fiduciary duty. The board needs to make a judgment in the best interest of the corporation.
Right. And in that particular instance, the justification for the board would be, yes, we're doing this upgrade to the pool with the ADA compliant, chairlift, not because we were forced to do it under a reasonable accommodation, but we as board members have decided that it's the best interest of the association to provide that amenity to the common area pool because we think it adds value to our project, because we anticipate at some point we're going to get a reasonable accommodation to do it, because as Jasmine says, we have some older members that may want to use the pool someday and they may need this. And rather than do it forcefully being forced to do it. We are going to be proactive and do it. And, I think that's, if you look at it like that, we're doing this as on the best interest of the association because we anticipate we're going to get this request one day.
Yeah. So how much detail needs to be on a document? Does it need to state what their disability is from the physician?
It needs to state that they have a disability. It needs to state what the accommodation being requested is, and it needs to establish a nexus, like some sort of connection between the disability and the request. I could say, I've got, I'm asking for a ramp to be installed. And that would suggest I have a mobility disability, but I could say, well, no, I have PTSD. And, you could say, I'm struggling. Where's the nexus? Like, where's the connection between those two? And it could be that my doctor says, and sometimes, the care provider or the person who's providing the, letter, the third party will say, it would be, hey, she was a military veteran and, there's reasons why. And so, there sometimes is not an obvious connection. And if there's not, you may press for a little bit more. You're not asking what's the diagnosis, like how crazy is she? So that's not what you're asking for. If a person were to turn over medical records, don't even accept them. You're like, oh, no, just those are yours. Like, we're not asking for that. We just wanted confirmation you have a disability and what's the nexus between what you're asking and whether we have to grant it or not.
Is anyone other than a licensed medical professional able to?
Oh, yeah.
What are marriage and family therapists probably qualify? Anyone?
It could be a nutritionist.
Yeah.
Like if you were to look at the number of qualified parties who can attest to a person's disability, it could be a nutritionist. It could be a community service worker that maybe you have some sort of a support from a municipality. So the list is not just limited to physicians. And I think that's important that board members understand. You may have a letter. I've had letters from parents. Mm-hmm. I had a request for a person to install a front screen door. She had an autistic son. They are prone to running away, not for like malicious reasons, but that's, sometimes how part of their disability manifests. And the board was like, she didn't provide a doctor's note. And I'm like, the mom is able to attest that her child is a disabled child. And, that was a struggle for them to accept, but she didn't give a doctor's note. And, it was like, don't put this woman through the paces to go get a doctor's note. And so, it can be difficult for, boards because you may have some sense of like, hey, we know that the doctor's note's necessary and they didn't do that. Mm-hmm. It could be that we say, all right, they didn't give us any qualifying, like any information. They just self-attested. If they send you their disability placard for their car, again, you don't get to ask them, are you sure you're disabled? You're like, well, the government has said they are because they've got a disability placard. You may be able to ask, what is the disability and the nexus? Simply having a disability placard may not have anything to do with, I need an extra hour to use the gym.
So a letter from you is not going to get me a disability placard?
It could. It could.
Here's a good question. Does ADA apply to common area outdoor trails? We have private trails that trespassers use and public trails with a county easement for the public and residents to use as well. The space is referred to in the CC&Rs. Being outdoor dirt trails and unfinished, they can be rugged and do not accommodate wheelchairs.
Paul, he's like, of course she wants that one. Trails is a tough one. There's actually a case, Orange Coast versus Carolyn. It's from like a decade ago. And it's not necessarily saying that you have to go and retrofit, walking paths that are intended to be dirt so that they are, paved and, fully maintained for someone to use a wheelchair or a, mobility assistance device. So that may not be what you have to do, but in the Orange Coast case, this person wanted to be able to like take a buggy. And there were bollards that prevented access, through the buggy. And, the court said, well, these trails are, even though people could come onto them, they're not meant for the public. It's not, if you go to the East Bay Parks Recreation District, this trail doesn't, pop up on the list. So simply the possibility that a member of the public could go to a trail does not make it a public trail.
Right. And I would also look at the documents for the project to see who's got the maintenance and repair responsibility. If it's, I don't know, I don't see the question anymore, but I think the county had some relationship to this trail. So the easement, if the county has an easement on the trail, under the law of easements, the county has some also responsibility for those trails. So it's not all on the association to, deal with any of these issues. We have private trails. Oh, county easement. So yeah, so I would pull the county into a discussion about, we have this potential request from an ADA person about, wanting to make some modification to a trail. You have an easement over it, so you're in this with us. What do you want to do? So when you have parties that have granted rights in areas of your common area or open space, those parties need to be involved. And by being involved, I mean get their checkbooks out if there has to be some sort of financial commitment to do something that the board believes needs to be done, exercising its fiduciary duty in the best interest of the corporation.
Is there any more that we have on ADA, or do we want, we're getting close on time here.
Okay.
If we want to take time to answer some of the questions we didn't get to, or if there was more we needed to cover on ADA.
No, we could cover that topic for days.
Yeah.
It's complicated. But no, I think we covered the sort of big,
Right.
the
Just to sum up, fiduciary duty means making decisions in the best interest of the association, the corporation. Members are going to be upset when you make decisions, either because they don't like it because it affects them directly, as in you denied my architectural application, or they're going to think that you were wrong, and you're allowed to be wrong as long as you're going through the process and falling within your duty as a director. You're allowed to be wrong, and you cannot be personally liable, and the association cannot be liable. In the context of a reasonable accommodation, it's a perfect example of the discretionary decision-making that board members have to make. And as long as you're doing it within the four corners of that fiduciary duty for the association, then you should be pretty well protected.
All right, we'll take like a couple of the questions off here. We're not going to get to all of them today, guys. What if an elderly resident is requiring or requesting to switch parking spaces because she will get an electric vehicle and an outlet is within reach? Should the board accommodate this? Can they charge extra for extra electrical charges?
Well, that person would first of all need to have a disability. So that would be number one. Sometimes requesting parties have a misunderstanding that I get anything. And again, you don't get anything, you get a reasonable accommodation. And it's only granted if there's you're a disabled person and there's a nexus and it's not otherwise unreasonable. And so, merely being an elderly person doesn't necessarily mean you're disabled. And even if you were, it was her choice to buy the electric vehicle.
Right.
She may have to factor that into the decision making.
Right.
Unless it was, hey, my doctor said I needed to get vehicle X because it's got, better bells and whistles. I mean, maybe it's a Tesla and it's supposed to be able to drive you. And it's like, well, I don't see well anymore and I need someone to drive me. So, maybe there is a nexus between I needed this specific vehicle and as a result, for my disability. And that goes to show that's that investigative part that the boards need to, in good faith go through.
We got a couple of questions about parking, handicap parking spaces and their guest parking.
It's a tough one. I have
standard.
answered many of these opinion letters and, I'll say it might be part of a reasonable accommodation that you have to grant a disabled homeowner the ability to park in an otherwise guest parking space that maybe residents aren't allowed to use ever. And you may need to put a, reserved sign so that people don't park in it. And they may say, but she's got a garage. She's not parking her car in the garage. And I call foul. It's, BS. And, it may be, hey, this person needed to buy a special, van that has better access for her, electric wheelchair. And she, doesn't get 2 parking spaces. You're like, well, you can't really make guests park in her garage. And, to that, I say, no, I understand that. And it's possible that you may imperfectly, because again, disabled people don't get extra rights, they get equal rights. And that's the part, that's the purpose of the statute. You may say, all right, well, we understand you have a parking garage and your vehicle can't fit in that parking garage. So we'll give you this designated spot. And your guests, whenever they come into the community, they can't use guest parking. They need to use your garage. And that may be the best that the association is able to do in terms of not giving, Paul 2 parking spaces.
Mm-hmm. Exactly. Sometimes you got to be a little creative, I guess. Yeah.
All right, I'm going to do one final question. Our owner is requesting an exterior chairlift based on the fact that she's aging and has a hard time going up the stairs. Is aging a disability?
If it is, I'm disabled.
Again, that's not for us to make that determination. It would be for her to provide, appropriate documentation from a qualified third party that, confirms. It's not because she's old, but it could be that, the person has, compromised knee or arthritis.
Right.
And as a result,
or something.
a combination of stuff. So the association's response should be, if it's just, hey, I'm getting old and it's really hard. And you're like, we feel ya. That, hey, we need for you to provide a, written support from a third party that confirms you do have a disability.
Mm-hmm.
So there you go.
All right. Thank you
All right.
guys for attending. We try to do these a couple times a year. We get so many requests for board trainings. And so stay tuned. Keep an eye on us on our website. Follow us on social. You'll see the announcements for these kind of things. This will be posted on our website in a couple days if you want to reference it or share it with other boards that couldn't make it.
Thanks.
Thank you very
joining.
much.
Thank you.